Good morning, everyone. We're going to wait just a couple more minutes to allow more people to join, and I'll be right back with you. Good morning, everyone. We're going to go ahead and get started. My name is Melissa Azallion Kenny, and I'm a partner with Burr Forman. I lead the firm's immigration practice, and I am looking forward to speaking with you today about school district immigration issues. It's hard to believe we're here in 2022, and we find ourselves, I know many school districts are already looking at how to meet their hiring needs as they think about the 2022-2023 school year. Our firm is a regional law firm. We're based really in Birmingham, Alabama, but we're focused all across the Southeast. We have 6 offices in South Carolina. And as it relates to our immigration team, we do a lot of work for public school districts in South Carolina. And, you know, one of the reasons that I like to have this webinar kind of at the beginning of the year as you head into your hiring season is it seems like we continually hear that there are districts that are struggling with finding teachers to fill vacancies. Sometimes those are in some shortage areas like special education, immersion, you know, and other types of positions. And I gave a presentation late last year, and I looked at some statistics really of what was going on in South Carolina and across the nation as it relates to hiring teachers. And many of you may be experiencing what these statistics reflect, but the bottom line is that there is a national teacher shortfall. A recent study across the US confirmed that the teacher shortfall in 2020 was about 300,000 less teachers than the prior year. And that just seems to be increasing every year. There were about 6,000 teachers that did not return to a teaching position after the 2019-2020 school year. And when you look at, you know, who those teachers are, I thought this was interesting. 42% of those teachers who left in 2020 had 5 or fewer years of experience, and 16% had 1 year or less. So they seem to be fairly recent teachers, you know, that are leaving that might be creating these vacancies. Of course, other reasons that people would depart the workforce, whether it's, you know, a teaching environment or other positions. Certainly COVID-19, we have the baby boomer generation retiring at a high rate. So there's a variety of factors that are creating this. But the reality is that I think many school districts do find themselves in positions where they have teacher shortages and they're looking for creative ways to fill those vacancies. The other interesting piece about some of these statistics that I read is that unfortunately in South Carolina, the supply of teachers in terms of graduates coming out of school really isn't sufficient to meet that demand. So that's also, you know, kind of a challenging area. But yet, you know, we need to fill the vacancies. And immigration is one strategy that does allow a district to do that. Now, we do have a lot of school district clients who use that. And I had a district client a couple of weeks ago that said, you know, that their impression was that a lot of districts use this strategy. But when you look at the statistics in South Carolina, there are relatively a small percentage of districts that use the immigration strategy. So what I hope to do today is talk with you about how immigration for teachers really works. We do have the chat box, so if you have any questions along the way that you would like to ask, feel free to list your questions in the chat box. And certainly my information here is on the cover slide, so if you would like to email me privately, I'd be happy to answer any question that you might have. So the first thing that I want to talk about are just some key immigration concepts and documents. Sometimes when we talk to district clients, about immigration issues, I think there's somewhat of a misunderstanding about how it really works. So I thought it might be good just to sort of lay the groundwork for you and make sure that you're familiar with the key documents and how things work. So in the world of immigration, we have non-immigrant visas and we have immigrant visas. Your non-immigrant visas are those strategies that are typically intended to allow a person to remain temporarily in the US with the idea that they will go back to their country of last residence or their home country. Non-immigrant visas can vary in length of time and purpose. So somebody may be able to come for 6 months or 3 years, and the purpose for which they come can vary. In the public school district setting, we find that teachers commonly use one of 3 visas: the F1 student visa that might allow them after graduation to work for a district in something called OPT or CPT, which you might be familiar with; the J1 exchange visitor visa program, which a lot of teachers use to come here and learn various skills through training and where they are getting paid, with the idea that they will take those skills back to their country at the conclusion of their visit; or the H1B, specialty occupation worker. So we're going to focus today, most of our time, on the J1 and the H1B. I did want to mention, though, that the second bucket, if you will, of immigration strategies are immigrant visas. And immigrant visas is a term that really refers to someone that has a green card or is a lawful permanent resident. Those are all the same thing. And a green card holder must have a permanent intent to live and work in the US indefinitely. Sometimes when an employer wants to obtain a green card for an employee, they do have to test the US labor market and demonstrate that there are no qualified US applicants. So we'll talk about that as we go further along today. The typical immigration path for teachers that I see is either a J1 or an F1, onto an H1B, and then onto a green card. There are some common documents that come up along the way that I thought might be helpful for you to know. A passport, most people that are entering the United States have a passport, and that passport is nothing other than an identity document. Similar to maybe if you have a US passport, that doesn't award them any particular status or indicate how long they can stay. It's simply an identity document that has to be valid at the time that they seek to enter the US. When someone prepares to enter the United States, they have to get a visa in their passport, and that visa is issued by a US consulate or embassy located abroad, typically, in their home country. And a visa will have a class type. You see in this particular example here, it's a J1 visa. And you see that there's a beginning and an end date. So this particular visa is July 7th, 2017 to June 30th, 2018. The visa only allows someone to attempt entry during that period of time. But again, this is not the document that tells us how long somebody can stay in the US or even what their status is. This is just an opportunity document that allows the person to seek entry to the US during the validity period of the visa. But in most cases, it is required for someone to have this visa in their passport when they're abroad and entering the United States. The document that really tells us how long somebody can stay and what their status is called the I-94. And I-94s can either be electronic, like the left side of the slide, or paper, like the right side of the slide. It used to be, until a few years ago, only paper I-9s were issued. And so this would be a card that would be stapled into the person's passport, and it would indicate the class of admission. So in this case, H1B. It would indicate the date that they came in, July 16th, 2012 in this example, and the date of expiration, August 4th, 2013. Recently, however, USCIS is now no longer issuing the paper cards. They're issuing the electronic I-94, which is what you see on the left side of your screen. In this particular case, you can see the person came in on July 25th, 2017. They came in F1 status, and they were admitted until what we call D/S, duration of status. And that is typically the expiration date for a J1 candidate as well. So that is the document that we would be looking at to determine how long somebody can remain in the US and what their current status is. This is called an I797 notice. If any of you are already filing H1Bs or doing any immigration work, you're probably familiar with these documents. You can see on the right-hand side that this 797 notice is an approval notice for somebody in H1B status from 11/15/2018 to 8/15/2021. The bottom portion of this form does constitute the person's I-94. So you'll recall these examples here. When somebody moves to H1B and the immigration office approves their H1B, the bottom portion of that 797 approval notice is their new I-94. So you can see on the right-hand side of the slide here, on the bottom left, we have a I-94 number, a receipt number, and we can see that the person was admitted in H1B until 9/25/2021. The last thing I want to show you a picture of is a green card. And so once someone progresses from an H1B to a green card, then they're issued this upon final approval, and you can see that the green card has an expiration date, and it tells us a variety of items about that particular person. So with that, let's start off today with J1s, because I know that most districts do employ teachers on J1s, and they're looking for, maybe some strategies to perhaps keep that teacher in that position beyond the J1 period. So typically a J1 is facilitated through a third-party J1 sponsor. Some school districts serve as a J1 sponsor, but most that I work with do not meet the requirements to do so. It's a very tedious process. There's lots of application materials and things. So most districts are going to work through a third-party J1 sponsor. When a teacher is in J1, they typically can remain in the US up to 5 years. And they have to have temporary non-immigrant intent, meaning they must intend to go back to their home country or country of last residence at the time that they conclude their program. Some J1 teachers are subject to what's called a 2-year home residency requirement. And what that means is at the end of their J1 period, they have to go back to their country of residence or country of last residence or home country for 2 years. Why do they have to do that? Because their country has deemed the area of study that they've been in as a shortage area. And they want the teacher to take those skills at the end of the J1 period and go back to their home country and utilize those skills. Not all countries have a home residency requirement. So that is important for a district to kind of assess, am I dealing with a teacher who has that requirement or not? If the teacher is subject to the 2-year requirement, it can be waived. And typically that's done through what's called a no objection waiver. Now this does take some time. Usually that is initiated by the teacher. My estimate of time is about 4 to 6 months. So you want to identify your 2-year issues and those teachers that are subject to that requirement fairly early. Why is that important? Because if you hope to take a teacher to a green card or an H1B, then they cannot move to those statuses until they either fulfill the requirement or they obtain the waiver. So let's move on now to the H1B. And when we talk about H1B sponsorships, we're talking about positions that are what we call specialty occupations. And the definition of a specialty occupation is a job that requires a bachelor's degree in a specific field or related fields. So a good example would be, for example, an engineer, a mechanical engineer, where the job requires a bachelor's degree in mechanical engineering or a related field. Or in the teaching space, it would be, a Spanish teacher, where the job requires a bachelor's degree in Spanish, education, or perhaps a related field. Those are typically commonly accepted as H1B specialty occupations. Now, H1B visas are employer specific, so they're not transferable from one district to another. But there are what we call portability rules that may apply. And what that means is if a teacher is already in H1B status working for a district and they want to move to a different district, usually at the time that the petition is filed by the new district, the teacher can start working. That is not the case in all scenarios, but that is sometimes an option. But just because you obtain an H1B for a teacher does not mean that they can then take that H1B to another district without a new filing. There is a 6-year maximum in H1B status, and we typically apply for that in 3-year increments. And that may be extended beyond the 6th year in some circumstances, and we're going to look at an example when maybe we can get a beyond the 6th year H1B if certain criteria are met. What are the benefits of an H1B? Well, it's really a good option to continue the employment of a J1 teacher beyond the 5th year. Many times if you find a teacher that you like, a teacher who wants to stay with your district, that your parents and students are pleased with, and that you want to remain, the H1B allows you to do that. It doesn't say at the end of the 5th year, there's not an opportunity, beyond this period of time. We talked a moment ago about that portability rule. So you can offer immediate employment to the teacher already in H1B status once you file your H1B petition. There is no home residency requirement. So there's no rule that says, when you finish your H1B status, you have to go home for 2 years or fulfill requirements in your home country. And there are some options for family members. They usually will have what's called H4 status. They can't usually work, but they can attend school. And there are some exceptions to that. There are times when they can work, but certain criteria have to be met. So when we think about H1B filings, if you are a district, maybe you've never used the H1B process, or maybe you do, and you're thinking about maybe adding some additional folks in the upcoming school year, what are some considerations from a teacher standpoint that you need to be thinking about? First, you need to identify and evaluate what teachers you have that might be available for H1B sponsorship. And you want to create a list of those teachers, thinking both in-district teachers and perhaps out-of-district teachers based on what you're seeing from a recruitment pattern. And, it may be early to assess that, but probably over the next month or two, this will be something where you may be contacted by teachers in other districts who might be interested in employment in your district. You want to assess the J1 time that the teacher has. Are they at the beginning of their J1 phase? Are they coming up on their J1 5th year expiration? And you also want to assess the 2-year home residency requirement. One comment that I'll make about the time that the J1 teacher has left, many times the sponsors will not take favorably when a J1 teacher tries to move to H1B before they finish their 5th year of J1 status. So what I see in my practice is most districts are waiting until the teacher will finish the J1 period before they seek to transfer them to H1B. So you want to understand your teacher's immigration status, and you also want to know when their status expires, because from our team's perspective, it's important that if we're going to file an H1B for a teacher, that we know when their status expires so that we can file the petition and have it approved, at least file it prior to the time that their status expires. So for J1 teachers, most of the time, their status is going to end on June 30th. Let's say we have a teacher who's ending their 5th year in J status. Most of the time, when I look at their documents, their status is going to end on June 30th. They do have a 30-day grace period. So what that means is that H1B would need to be filed prior to the end of that 30-day grace period. Maybe you have a teacher that's already in H1B working for another district. Well, in that case, the termination date when they will depart from that district is very important. So those will be things that we would be asking you along the way, but they're also helpful for you to sort of know in advance as you plan and strategize your upcoming hiring needs. It will be necessary to gather relevant documents for attorney review. In our practice, we use an immigration portal. So that's typically how we communicate with the teachers and sometimes with the districts. Other ways that we might gather information would be through an Excel spreadsheet or something like that. But we do have a portal that you can communicate with us as well to share information. What are some district considerations? First, you need to ask, does my district qualify for H1B cap exemption? And most public school districts in South Carolina are going to qualify if they have a dual enrollment agreement or a student teaching agreement. I'm going to presume that everyone on the call is generally familiar with those, but typically these are agreements where your school district has an arrangement, a written agreement with a college or higher education to offer dual enrollment opportunities for students, typically at the high school level, or maybe there are some student teaching opportunities. But that is important that we know that those agreements exist and that they're current, because that's going to allow the district to qualify for H1B cap exemption. Now, what do I mean by that? You know, if any of you have been in this arena for several years, you will know that one of the challenges that districts have had in the past is that they would compete for a very limited number of H1B slots. And we call that the H1B cap. And so there would be a lot of frustration. You know, districts and other employers would file these petitions and spend a lot of money only to be told that there wasn't available H1B slot. Well, now with these types of agreements in place, districts are now exempt from that cap, which means at any time throughout the year, they can file an H1B petition. So this is a great benefit for public school districts with these kinds of agreements. The other thing that you want to ask is, has there been an offer and an acceptance? Sometimes we do get referrals from districts before that has occurred, and that is always a difficult thing, because the teacher, you know, is contacted by the council to begin the process, but they really don't know if they've had an offer and what the offer is and how much they're going to make. So it is important when we're talking about immigration issues for there to be an offer and an acceptance before we begin working on the case and we start moving forward with the H1B process. The other thing that you want to think about as a district are fee considerations, because those are going to come up right away. The teacher is going to likely ask you, you know, are you covering the attorney fee cost? Are you covering the filing fees? What about my family? You know, my family needs assistance. Is that something that you district are going to cover for me, or is that my independent responsibility? The other thing that often comes up is premium processing. Premium processing is a process by which the immigration office allows cases to be expedited. For $2,500, you can get a decision in 15 days. And many teachers like to do that, but of course it's costly. So you may get asked that question and want to be prepared for whether you will or will not do premium processing. Another thing that I want to mention to you is the idea of teacher certifications. Teacher certifications for H1Bs are different than J1 teachers. J1 teachers have what we call an international certificate. H1B teachers must have an initial certificate. If you have a teacher in F1 status, they also typically can obtain an initial certificate. So the way that that's typically done is working with the South Carolina Department of Education. They have some contacts there that will help your district and help the teacher get the correct certification. Sometimes they may have to take praxis exams in different areas, maybe than what they had to take initially. So getting those requirements, understanding what praxis requirements exist, assessing the timing considerations, and making sure that your teacher can obtain the correct certificate is very key. The teacher has to have all of the requirements met for the initial certificate before we can file the H1B. Now, there is an exception to that, and that is the letter of agreement. So if we have a teacher who maybe can't pass the praxis, maybe they've tried to pass the Spanish immersion praxis examination, and they're very close, but they end up not passing. Are there options for that teacher? That's when the letter of agreement can come into play. And this is something that is permissible under South Carolina law. where the teacher is supervised by another certified teacher. We collect and gather, certain documents that have to support that letter of agreement. And typically that can last for up to 1 year. At the end of that year, then the teacher typically would have their certification, and then we could extend their H1B. So that's typically how that works. Some other things that you might want to think about are wage issues. Most districts are going to have a designated salary schedule, they're going to adopt on a yearly basis. But when we're talking about H1Bs, we have to make sure that we're paying the teacher the higher of the actual wage or the prevailing wage. And those are things that, our team would be working with your HR folks on to determine. One of the things we're often looking at are what are comparables in your district making? And a comparable is somebody that is in a similar position, usually working for the same school. And what I mean by that is, a district has many schools, maybe you have several high schools. So if a teacher is in ABC school, then we might look for other teachers that are doing that same position in ABC school. And those are called comparables. Why do we look at those people? We want to make sure we want to be able to prove that we're not underpaying the teacher, the H1B teacher, based on their skills and qualifications. But again, oftentimes we're bound by the salary schedule, because depending on the teacher's education and experience, that determines where they're listed on the salary schedule. The last thing I want to mention is sometimes districts do try to pass along certain H1B costs to the employee, but the law says that those are employer business expenses. So if you do that, it's just important that you understand sort of the wage deduction rules, and that's carefully vetted with your legal counsel, because you don't want to run afoul of some of the wage deduction rules there. In my practice, I would say most employers, most school districts are going to cover the H1B legal and filing cost for the employee. There are times when it's important, once somebody's in H1B status, to notify your immigration counsel because it can impact your obligations and the person's H1B status. So one of those areas is layoffs or furloughs. If you have an H1B employee and you need to lay them off, that is important to contact your counsel, because you may still have to pay the continued wages for that employee despite the layoff. So you would want to know that in advance. If they change duties or work locations, maybe you have a teacher that is a middle school Spanish teacher, but you're going to change them to a high school math teacher. That would be a material change. And so that would be something that your counsel would want to be notified of prior to you doing that. If you reduce their wages, maybe you demote them, that's another time that it's important to connect with counsel. And if you terminate them, there are some obligations that say your obligations really as a district continue unless you notify the immigration office, the Department of Labor, that H1B has ended. So it's important to understand that. Okay, timing considerations. Right now it's taking 6 to 8 months for H1B approvability. That's probably the highest that I've seen it. Why is that? I think it has a lot to do with COVID and staffing. And a lot of these immigration offices are very backlogged. So we're seeing this across the board on all kinds of cases. So just remember, not only do you want to start early in this process, but you also may need to think about that premium processing option, which gets you the decision in 15 days. When do you need the H1B approval? If you have somebody transitioning from J1 to H1B, you need the H1B approval before they can begin working for your district. If you have somebody already in H1B, maybe you're currently using the H1B process and you have teachers coming up for expiration, those can be filed up to 6 months before the expiration. So that's also another reason, given this long processing time, to start early and really get those cases in the queue. All right, next I want to talk about green cards. And as I mentioned, the typical process would be J1 to H1B to green card. And most districts use either what we call the EB2 or EB3 green card process. EB stands for employment-based. So when you get a green card, you either typically get that through a qualifying family relationship or you get it through an employment relationship. If you're using the employment relationship, so a district is sponsoring you, typically it's a 3-step process. We start with a perm labor certification, we move to an I-140 petition, and we ultimately end up with an I-45 adjustment of status or consular processing case. One of the things that has to be considered at the outset is what are the green card backlogs? There are only about 140,000 employment-based green cards issued each year, and there's a 7% per country cap. So what that means is if people from one particular country apply for a lot of green cards, their green card allotment, 7%, quickly becomes backlogged. And we see this a lot for Indian and Chinese nationals. So the way that you determine whether somebody is going to have a green card backlog is you look at a document called the Visa Bulletin, and you compare what we call priority date is with that Visa Bulletin. Their priority date is the day you file their case. And so that sort of determines where they are in the queue. And that's something that, we would be communicating with you and explaining along the way and giving you some estimates for how long it might take to get a green card for someone. The thing that I want to emphasize for you relates really to this first process, perm labor certification, because what you're doing in perm is you're beginning the green card process, first of all, and you're also testing the US labor market. You're proving that there are no minimally qualified US applicants for the job. So you do that through advertising in newspapers of general circulation. You do some other recruitment. There's a variety of things that you can do. It's very regulatory, and you will want to stay in close contact with your counsel as you're working through that. But a lot of questions we get relate to timing. When should I begin the green card process for a teacher? And our recommendation is that you evaluate that no later than the 4th year of the teacher's H1B status. Now, when I say the teacher's H1B status, remember that they may have come to your district already in H1B. So if that's the case, you want to know their total H1B time from any prior employer as well as with your district, because when we're looking at a 6-year maximum H1B status, we count all of the person's H1B time, regardless of who employed them. So here's an example. Sue starts working at ABC District in H1B status on January 1st, 2018. She moves to XYZ District in H1B status on January 1st, 2021. And she currently works for XYZ, and her status expires on December 31st, 2023. So we know Sue has moved districts. We know that she was in H1B in the prior district. She's in H1B in our district, and we know that her status is valid until December 31, 2023. XYZ should begin the green card process for Sue in 2021, which is her 4th year of H1B status, but no later than 2022, her 5th year, because her maximum stay in H1B will expire on December 31st, 2023. So let me pause and say, if Sue is a valuable employee and somebody that you'd like to keep beyond the H1B 6th year, by starting the green card process within these timeframes, there may be an opportunity where we could extend Sue's H1B status beyond the 6th year. Okay, so that's the last bullet point here. The timely filing of a green card application may allow a district to extend Sue's H1B status beyond the 6th year. And what we typically do when we're working with a district and somebody is in H1B status is we track that 6-year maximum for you and try to inform you, when that status might be expiring and where you fall along that continuum of the 5th year and the 4th year, so that you can timely begin. Sometimes you may choose not to do a green card sponsorship for someone. But if you want to take advantage of employing somebody beyond that 6th year in H1B, those timing considerations become important. All right, and that is all I have for you today. I don't see any questions in the chat box, so if you do have anything please feel free to go ahead and put it in the chat box, or if you would like to just email me or call me, my email and my phone number are listed here on the screen. But I look forward to hearing from many of you, and thank you for your time today. I hope it was valuable, and I hope you learned something about the J1, H1B, and green card sponsorships for teachers. So have a great day and have a good week. Thank you.